Hey, my name is Trent, just call me that, also known as Bar Auditor ESQ. I am the creator of the channel Exposing Bar Secrets. No, we're not talking about Chevys from the corner, we're talking about the Florida bar. And basically, I'm an attorney that has been kicked out of the bar for being probably too good at my job and fighting a little too hard for the 99%. And that might sound like a preposterous claim to some at first, but that's why this channel is open to doubters just as much as it is open to supporters, because I want you all to just take a walk along this experience of reality with me and consider this bar complaint, see if you guys think it has any merit to it, and then see what it is that the Florida bar does with this complaint. By me against Navin Ramnath. Navin Ramnath was bar counsel in an ethics proceeding against me. The case included accusations of wrongdoing arising from my representation of two different clients, Nelvery Scott and Anna Martin. There's a footnote. Footnote 1. This complaint is not to be misconstrued as an effort to appeal or overturn the sanctions imposed against me in the referenced disciplinary proceeding. Navin Ramnath violated the rules of professional responsibility in the disciplinary proceeding arising from my representation of Ms. Scott. Nelvery Scott hired me to defend a foreclosure. The bank's lawyer informed me that Ms. Scott had already surrendered her home in a Chapter 13 bankruptcy. Ms. Scott vehemently denied this and asserted that her counsel had agreed to surrender the home without her knowledge or consent. I filed a motion in the bankruptcy case to vacate the agreed order of surrender. The bankruptcy judge denied the motion and ordered her to hand the property over to the bank in the state court foreclosure case. Ms. Scott decided she would rather dismiss her bankruptcy and lose her discharge than surrender her house. After research, including a law review article entitled "The Chapter 13 Debtor's Absolute Right to Dismiss," I filed a notice of voluntary dismissal of the bankruptcy case on Ms. Scott's behalf. 2 hearings were scheduled. The first was set for May 9, 2017, at which time the state court would entertain the bank's motion for judgment of foreclosure. The second, which was scheduled for May 25th, was in bankruptcy court for consideration of Scott's notice of voluntary dismissal. Ms. Scott and I attended the May 9th hearing, hired a court reporter, and later bought the transcript. No judgment was entered at that time. A few weeks later, the bankruptcy judge entered an order stating that Ms. Scott and I had abused the bankruptcy process and acted in bad faith by not unconditionally consenting to a foreclosure judgment on May 9th. The bankruptcy judge ordered me to send 2 of his orders to Chanel Schuyler, director of intake at the bar. On June 27, 2017, I did so. I enclosed a cover letter and the transcript of the May 9th hearing. My letter to Ms. Schuyler is attached hereto as Exhibit A. The transcript is not provided due to your page limitation, but will be furnished upon request. As explained in Exhibit A and as demonstrated below, the transcript is strong evidence of my innocence. Navin Ramnath then undertook, as directed by his superiors, to bring ethics charges against me, claiming that I violated a court order when on May 9th I did not expressly and unconditionally consent to the entry of an agreed final judgment of foreclosure against my client's homestead property. One need only read the transcript to understand that my position and commentary during the hearing were forthright, motivated by a sincere desire to shield my client from injustice, and well supported by legal authority. On page 17 and 18 of the transcript, for example, I said, "Your Honor, Ms. Scott's position is that she cannot oppose the entry of judgment, but she consents with the condition that it not be entered until after the hearing on the 25th, or that if it is entered today, it contains a provision that it's vacated in the event that her Chapter 13 is dismissed." This simply does not appear on its face to be any sort of bad faith conduct. Navin Ramnath concealed, disposed of, or lost the transcript, which would have made my good faith apparent. Due to Ramnath's actions, the very best evidence for me was not presented to the grievance committee or was hidden until the very last minute. The transcript is exculpatory because, based on his questions and commentary, the state court judge, Honorable Barry Stone, seemed to find my position to be reasonable and appropriate. He replied to the bank's counsel, "I think what Mr. Trent is basically simply saying is, Judge, There's a hearing scheduled on a motion to dismiss the bankruptcy, close quote, transcript pages 9 and 10. Judge Stone stated in essence that he did not believe the bankruptcy judge should be making the rulings in his courtroom, transcript page 15. He kept asking counsel why she couldn't just wait for the dismissal hearing in bankruptcy court, e.g., transcript page 8. The transcript decimates the idea that I acted in bad faith, and unbeknownst to me at the time, Nav and Ramnath decided to conceal it. The disciplinary proceedings commenced with Nav and Ramnath acting as bar counsel. He and I communicated throughout by email and, up to a certain point, by telephone. The case was scheduled to go before the 17th Circuit's Grievance Committee on July 11, 2018. I had the right to submit written argument to the committee prior to the meeting, at least 10 days prior. Allison Klein, Nav and Ramnath's assistant, sent me a list of exhibits. On June 19th, I emailed Klein and Ramnath asking for copies of Exhibits 5 and 9. I received no response. I followed up on July 9th, asking again for 5 and 9. The exhibits were then provided. One of those two exhibits was correspondence from Nav and Ramnath to the State Court Judge Barry Stone, dated February 9, 2018, Exhibit B, which I had never seen before. This was the first time I learned that Judge Stone had informed Nav and Ramnath that it was apparent to him that during the May 9th hearing, Mr. Trent was forthright with the court as to the status and circumstances, Exhibit B. In his letter, Nav and Ramnath did something very strange. He asked Judge Stone for that May 9th hearing transcript. In the letter, Nav and Ramnath not only requested a copy of the transcript, but he also saw fit to inquire of Judge Stone about my conduct during the hearing. Trial judges do not normally serve as transcript repositories, and the transcript is all that could possibly be needed to determine what I did at the hearing. According to the letter on February 9, 2018, Nav and Ramnath needed Judge Stone to tell him, quote, when Mr. Trent informed him that the federal bankruptcy court had ordered the surrender of his client's property, close quote, Exhibit B. The transcript answers that question in a manner not to Nav and Ramnath's liking. Why was he asking Judge Stone? I first received a copy of Nav and Ramnath's baffling ex parte communication 4 months after he wrote it, and only 2 days prior to the Grievance Committee's vote in my case. On July 10th, I emailed Nav and Ramnath a letter about the situation, Exhibit C. Exhibit C contains more detailed information and is to be considered part of my complaint. I concluded it in the following manner. I believe I am entitled to a response from you as to whether you were furnished with the supporting materials, including the transcript, sent to the bar on 6/27/17 prior to your February 2018 request to Judge Stone. Nav and Ramnath replied that, quote, yes, we are providing the transcript and the letter from Judge Stone as indicated in the notice of hearing to the Grievance Committee today. Close quote, Exhibit D. I followed up by asking, you mean they still didn't have it prior to today? I sent it in with the initial letter in June of 2017. Why wouldn't they have had it before the day of the vote? Exhibit D. Nav and Ramnath then accused me of having, quote, misread, close quote, his email. By the conduct described above, Nav and Ramnath engaged in ex parte communication with Judge Stone and concealed exculpatory evidence from the committee or provided it at the last minute, depriving the committee members of sufficient time to review it prior to the meeting and vote. He failed to acknowledge the evidence provided to the bar on or about June 27, 2017, and proceeded to prosecute charges as if the exculpatory evidence did not exist and had not been provided. He failed and refused to disclose his improper ex parte communication until after I asked for a copy of Exhibits 5 and 9 on multiple occasions. The conduct of Nav and Ramnath was totally unfair to the opposing party and was highly prejudicial to the administration of justice. Nav and Ramnath abused his authority in a manner designed to deprive me of due process. Nav and Ramnath violated the rules of professional responsibility in the disciplinary proceeding arising from my representation of Anna Martin. On the Anna Martin side of the case, Nav and Ramnath and his boss managed to distill a sliver of rationality from a rambling and mostly nonsensical complaint infused with sovereign citizen gibberish. Nav and Ramnath alleged that ethical violations occurred when I, quote, blew the statute of limitations close quote, and when I failed to stay in touch with Ms. Martin during my 5 to 7 years of representing her. Something seemed amiss. Even though Anna Martin's claims were meritless, Navin Ramnath was demanding draconian sanctions and prosecuting them aggressively. The other side's conduct can make an attorney suspicious that something other than objective justice may be coming his way. Upon perceiving a diminution in the likelihood of winning, a competent counsel naturally becomes more interested in settlement. Because I was in doubt as to Navin Ramnath's motivations, I wanted to make an offer to Ms. Martin. The last thing I wanted to do was run afoul of some ethical prohibition against settling a bar complaint. I read the rules of professional responsibility and found nothing on point. Since there was no rule prohibiting it, it seemed to me that there would be nothing improper about me making a settlement offer. Just to be sure, I asked Navin Ramnath about it during a phone conversation. I inquired of Navin Ramnath whether I was, quote, allowed to make a settlement offer to Ms. Martin, close quote. He replied simply that, quote, the bar would be able to proceed anyway, close quote. Period. Exhibit F. Yeah, this conversation is confirmed by the email enclosed herewith as Exhibit F. My version of events has never been disputed by Navin Ramnath. The reply from Ramnath was intentionally deceptive. C. Comment to Rule 4-3.3, quote, there are circumstances where failure to make a disclosure is the equivalent of an affirmative misrepresentation. As he intended, I understood his response to mean that the offer would not be considered a new violation of the ethics rules. I made the offer, Anna Martin rejected it, and Navin Ramnath brought charges against me arising from it. He contended that my offer was covered by a broad provision prohibiting, quote, conduct prejudicial to the administration of justice. Anna Martin's complaint was determined to be without merit, but I was convicted of misconduct related to Martin based solely upon the settlement offer. If Navin Ramnath's conduct does not offend the legal conscience, one does not have one. Navin Ramnath acted in an extremely unethical manner by leading me to believe I was permitted to make the offer and then prosecuting and convicting me for doing so. Had Navin Ramnath not been prosecuting me on a baseless and borderline insane set of accusations from an impaired former client, there would have been no need for me to make the offer. Had Navin Ramnath not intentionally misled me during the phone conversation, I would never have made it. In order to conjure up additional charges, Navin Ramnath entrapped me into making an offer. Navin Ramnath's actions exemplify the very thing he accused me of. Conduct prejudicial to the administration of justice in violation of Rule 4-8.4D. Justice requires that Navin Ramnath be disciplined. So we have all the exhibits here, boys and girls. Exhibit A. I wish I was better with technology. Here's my letter to Miss Schuyler from the very beginning, where I enclosed the transcript that he claimed not to have later. You see, I have all the evidence that one could ever need. Everything I said in there is backed up by the materials attached here too. It's 22 pages under the bar's preposterous page limitation. And we're going to shoot this one up the chimney and see how it fares. What do you think, guys? Hey, thanks for coming along with me again. Just call me Trent. Call me Bar Auditor ESQ. You can call me sarcastic occasionally, but you can also call me Right. So, this is striking another blow at the heart of another corrupt bureaucratic institution. Thanks for coming along, guys. We'll see what happens.